Hi, my name is Louise, and I'm an associate in LegalVision's employment team. Welcome everyone to today's webinar on employment essentials for startups. Before we begin, I have a couple housekeeping items. So firstly, you'll receive the recording and slides in your email. So you don't need to, take notes and everything. If you have any questions, please submit them in the Q&A box and we'll answer them at the end. And if you could please complete the survey after the webinar. So for the next 48 hours, you are eligible for a free consultation with LegalVision to discuss how we can help your business. If you just want to provide your contact details in the survey at the end of the webinar, and we'll reach out to you. Before we get started, we are running a poll question, which is, what is your biggest concern as a startup when hiring employees? So is it understanding employment laws and agreements, managing costs like wages and benefits, offering competitive perks to attract talent, avoiding compliance mistakes, or I'm not hiring yet, just learning? So while I give you some time to answer this question, I'll just go through our agenda for today. So firstly, we'll be going over how to categorize workers and the main difference between contractors and employees, the different employment options, including different types of employees, and also employment entitlements, including different remuneration options, what your employment might look like as a shareholder and director. The legal requirements you need as an employer, such as minimum wage, record keeping, and the difference between trial periods and probation, protection of IP, confidential information, and restraint of trades, and lastly, compliance monitoring. So staying ahead of changes in employment law, including potential upcoming updates to things like unjustified dismissal claims in 2025. So we'll just start up to talk about how to categorize workers. So as a startup business owner, ensuring you meet your obligations to workers is extremely important for maintaining compliance with New Zealand law. A critical distinction exists between employees and contractors, and misclassifying a worker can result in serious financial and legal consequences, including issues with PAYE deductions, so tax, and KiwiSaver contributions, ACC levies, and compliance with minimum employment standards. So, understanding this distinction is important when it comes to protecting your business, and it's helpful to get this right at the beginning. So firstly, I'll discuss what the key differences between employees and contractors are. So firstly, we've got working hours. So employees typically have set working hours determined by their employer. So contractors, on the other hand, typically have the freedom to decide their hours as long as they meet the agreed upon deadlines or deliverables. Number two, we've got control over work. So employees work under the discretion and control of their employer, and they follow workplace policies and procedures, whereas contractors have the autonomy over how they complete their tasks, are not subject to the same level of oversight from their employer. They can still be subject to workplace policies, but normally this is more for a health and safety reason rather than anything else. The third one is payment. So employees are paid on a regular basis. So this could be weekly, fortnightly, monthly, and this is in exchange for their time, regardless of the outcome of their work. So contractors are paid upon the completion of an agreed task or deliverable project, and they often invoice and are responsible for managing their own GST and own income tax obligations. And then we've got tools and equipment. So employers typically provide employees with their tools like, computers, hammers, anything like that for whatever industry you're in, equipment or even allowances to perform the work. So contractors are expected to supply their own tools and equipment as part of their independent operation. And we've also got tax. So touching on before, for employees deduct their PAYE tax and send it through to IRD. Contractors, on the other hand, are responsible for filing and paying their own taxes, including things like GST if it is applicable. And then we've got leave entitlements. So employees are entitled to statutory leave. So that's anything including annual leave, sick leave, public holiday, bereavement leave, or family violence leave. And that's all set out in the Holidays Act. So contractors don't receive these entitlements and normally factor leave into their business operation or their invoicing fee. So jumping back to the poll question, I can see the biggest concern for most startups at the moment is understanding employment laws and agreements and also avoiding compliance mistakes. So we'll touch on both of those during the webinar. Perfect. So just moving on to protecting your business. So there is a distinction between employees and contractors, which is determined by what we call the real nature of the relationship. So this is assessed through several factors, which are normally outlined in New Zealand case law, but also in the Employment Relations Act. So while the terms of the written agreement are very significant, the courts also consider how the actual working relationship operates in practice. So in order to protect your startup, you do need to ensure that your contracts are clear from the get-go. So clearly outlining the nature of the working relationship, whether it's employment or contractor, and then specify the respective rights and obligations. It's also important to regularly review agreements. So circumstances change. Sometimes contractors end up becoming more of an employee. They integrate a bit more into the business. So periodically reviewing contracts to ensure they still reflect the true nature of the relationship is very important. And lastly, we have understanding the risks. So misclassifying an employee as a contractor can result in liabilities for things like unpaid PAYE, leave entitlements, and penalties for breaching employment standards. So it is very important to seek advice if you aren't sure because each situation will be slightly different. So next, we'll be discussing different types of employees in New Zealand. So there are several types of employment arrangements, and it is quite easy to get them confused. So I'll be discussing the three employment types, which are permanent, casual, and fixed-term employees. So starting out with permanent employees, they are also known as permanent full-time or permanent part-time employees. They tend to have an ongoing employment with no set end date. They work regular and guaranteed hours, and they're also entitled to all minimum employment rights. So that includes annual leave, sick leave, public holiday, bereavement leave, and family violence leave. So moving on to casual employees, this tends to be a bit more confusing. So casual employees work on what we call an as and when required basis. So there is no guaranteed hours of work for a casual employee, and they can refuse shifts if they are offered by the employer. And as an employer, you're not obligated to actually offer regular work either. So casual employees are actually entitled to annual leave, but typically this is paid out as an 8% of gross earnings with each pay rather than a lump sum, time to take annual leave, as with permanent. They are entitled to sick leave and bereavement leave, but this is after 6 months of starting work if specific criteria are met. So that specific criteria is essentially they have to have been working for 6 months with either 10 hours per week or more every week, or at least an hour a week or 40 hours in a month for 6 months. And then they're also entitled to public holiday pay if they normally work on that day. And again, they're also entitled to time and a half on working a public holiday. So for fixed term employees, this one can also be a bit more confusing. So they are employed for a specific period of time or until a particular event occurs. For example, a project finishing. So there must be a genuine reason for the fixed term, and the employment agreement must specify the actual end date or event of why their fixed term is finishing. So they are entitled to the same minimum rights as permanent employees, but it differs slightly. So, for example, fixed term employees who have a contract to work for less than 6 months won't become entitled to sick leave or bereavement leave because that kicks in after the 6 month threshold. They will be entitled to annual leave, just like casual employees, but as this accrues, as it accrues, but typically, it's paid out similar to casual employees through the 8% of gross earnings rather than a lump sum period of time. So it's key to remember that fixed term cannot be used as a trial period, and employment ends on a specific date or event unless it's renewed or made permanent. So understanding these different types of employment arrangements is important for hiring your first few employees as a startup. So we'll now move on to discussing different remuneration options. So obviously we've got the standard wages and salary that we normally have, but there are some other options such as ESOPs, which are employee share option plans, and sweat equity, which are increasingly more common in the startup space. So starting off with the most standard wages and salary. So wages are typically an hourly rate based on the number of hours worked. So generally for this, if any overtime is worked, the rate that should be paid is the same, or if you agree to a higher rate than the standard hourly rate that is paid to the employee. And then salary are more fixed payments. So generally for this, it's an annual sum, which is divvied out according to the working days. So generally, there's no overtime pay associated with this unless you otherwise specify. And it's important to be aware of falling below the minimum wage obligation if they are working overtime. And so on to the less common remuneration types. So we've got ESOPs. So despite the name, ESOPs can also be provided to contractors. But essentially, this is where you allow employees or contractors to purchase shares in the company at a set price at a later point in time. So this generally incentivizes employees or contractors to put more effort into their work. And there's essentially a sense of ownership within the company. It allows for longer term commitment because there is commonly, a vesting period that associates for example, 5 years with a 3-year cliff period. So we've also got profit share schemes. So this is where employees or contractors will share company profits as a form of bonus. So similar with ESOPs, it works well with a lot of growing startups. So with directors and shareholders of a startup, it can be quite common that the business is a bit low on cash when you start out and while you're waiting for a cap raise, for example. It's important to note that the duties of directors and shareholders are not the same as employment duties that exist, and it shouldn't be confused because one is to do with the corporate structure of the business and one is more employment based. What has become increasingly more common within the startup industry is that lots of directors and shareholders who also essentially have an employment relationship with the company, um, is that their remuneration is paid out in the form of what we call sweat equity. And so this is essentially ownership interest for work that's completed and based on the value of the work that's contributed rather than a financial figure, for example, a salary. So this is typically a common way to compensate founders or early employees and consultants, but essentially the payment is only valuable if the company does well and succeeds. It's also important that if you're wanting to utilize any share option plans or sweat equity, that you seek specific advice if you aren't sure which one is most suitable for your particular situation. So we'll move on to talk about some essential terms you'll need as a startup business. So firstly, we'll start off with minimum wage. So at the moment, the minimum wage is 23.15 per hour. And this applies to workers who are age 16 and over and doesn't include start-out workers or trainees. So start-out workers and trainees are paid at 80% of the minimum wage, which at the moment is 18.52 an hour. So the minimum wage is typically reviewed annually and is actually due to change on the 1st of April this year, and it's going up to 23.50. It's important that if you do have anyone on a salary that the hourly rate doesn't fall below minimum wage, especially if their salary is on the lower end, and if they need to work overtime, because the employee's salary is meant to cover any potential overtime as well. Next one we'll move on to is record keeping requirements. So employers must keep records for at least 6 years. So this means you should be keeping all of your employment agreements for at least 6 years before you dispose of them. So this could be a digital copy or a physical copy. Obviously, for best practice, you should always keep an electronic copy in case you misplace any physical documents. So all employees must have a written employment agreement, and if your employee doesn't have one, it can actually result in a fine of $1,000 if found out by the Labour Inspectorate. And just moving on to important clauses for drafting an employment agreement. So obviously it's important that you have a well-drafted employment agreement in place with your employees to document the employment relationship. A good employment agreement will essentially have the following information included. So names of both the parties, so the company and the employee, the description of the work, so this could be the duties or the job description, the place and hours of work, the remuneration, so whether it's salary, wages, or an ESOP or sweat equity, the nature of the employment, so whether this is permanent, casual, fixed term, part-time, and also the notice period, which is typically somewhere between 2 to 4 weeks. Employment agreements must also have a clause on how to resolve employment relationships. So especially within the startup space, it's really beneficial to have clauses on how to handle things like confidential information, IP, and restraints of trade, which we will touch on later, but they aren't mandatory for employment agreements. Another important clause to have is the 90-day trial. So since December 2023, all businesses are now eligible to use 90-day trials. Since there are some strict rules around their validity, you do need to ensure that you have met them to have a valid 90-day trial. So essentially, the employee must not have worked previously for your business in any capacity, and the 90-day trial must have been agreed to before the 90 day starts in writing. So essentially, the employment agreement must have been signed before the employee starts working. So there is case law that has pretty much stated that signing the agreement even an hour after starting work will avoid the 90-day trial. So the reason it's beneficial to have a 90-day trial included in the agreement is that employees essentially cannot raise a personal grievance for unjustified dismissal. This still means they can raise other types of personal grievances, so unjustified disadvantage, discrimination, harassment, etc. And it's also important to note that the 90-day trial is for a maximum of 90 calendar days and cannot be extended past the 90 days. So in the situation where you have an employee returning to the business or changing into a different role within the business, you obviously cannot use the 90-day. What you can do is opt for a probation period. So it's important to note that you can still terminate an employee under the probation period, but you still have to follow the proper process. So that's either through something like performance management, a genuine restructure and redundancy, or a disciplinary process. So the process here is definitely a lot longer than terminating someone under the 90-day trial. And the purpose of the probation period is essentially to assess the suitability for the role and provide a period of time for the employee to have adequate training and support. Employees do have the ability to raise a personal grievance, though, for unjustified dismissal. So it is important that a proper process is followed if you do want to terminate someone on probation. I will also just touch quickly on KiwiSaver. So employers have to contribute to KiwiSaver. The minimum contribution you have to make is 3%, and this applies to any permanent or fixed term employees. For casual employees, because it is on a as and when required basis, the employee can opt in for KiwiSaver, but they don't need to automatically be enrolled. In short, it is important that all employees do have a written employment agreement before they start work, which outlines the key aspects of their role to prevent any misunderstanding. And you should regularly review and update employment agreements to stay compliant. So now we'll move on to the next topic of intellectual property and confidential information. So IP refers to legally protected creations of the mind, and that includes things like copyright, patents, trademarks, and designs. So these rights give owners exclusive control over their creations for a specific period of time. This in contrast with confidential information, which is valuable non-public information that businesses keep secret. So that could be things like trade secrets or business strategies. And it's primarily protected through contractual arrangements, and the law of breach of confidence would apply rather than a formal registration. So why it's important for startups. Startups often operate in a highly competitive and innovative market. So failure to safeguard confidential information can essentially lead to things like loss of IP and also loss of competitive advantage. It can result in breaches of privacy laws and result in associated penalties. It can damage client trust, and also ruin business reputation. So, confidential information protection is very vital in the startup tech sector, where things like data, algorithms, and trade secrets are essentially the core assets of the business. So, it's important to deter employees from starting up competing companies or poaching clients or employees once they leave. So protecting IP and why it matters. So turning first to IP, for many startups, IP is the most valuable asset. So whether it's innovative software, proprietary algorithms, or original content, securing and protecting IP is essential to maintaining the competitive edge that you have as a startup. So by taking proactive steps like addressing IP ownership in employment agreements, you can save yourself a headache down the line if a dispute arises. So why should IP be addressed in employment agreements? So if your employees are creating or contributing to IP as part of their role, it is important to make sure that you have clear ownership over those creations. And that includes IP provisions in employment agreements, which achieve two key goals. So firstly, securing your rights, and secondly, avoiding disputes. So ensuring your business owns the IP that is developed during the employment gives you the freedom to use it as needed. And then it also reduces the risk of disagreements with employees, whether or not they're current or former, about who owns what. And what should IP provisions cover? So when adding IP terms to employment agreements, you should consider a couple things. So, firstly, defining IP. So, what does IP mean in the context of your business? So, this could be things like software, inventions, creative works, designs, or even just ideas. And secondly, ownership statement. So, having a clear statement in the agreement confirming that any IP that is created by the employee as part of the job belongs to the employer. And thirdly, assignment clause. So having a provision where the employee formally assigns all rights to any IP they create while working for you, both now and in the future. And four, we've got confidentiality obligation. So requiring employees to keep IP confidential. So this is both during their employment and after they leave. So just touching on moral rights. So moral rights are there to protect the personal connection an individual has to their work. So this is like being acknowledged as the creator. So it could be writing an article and being recognized as the author of that article. So while these rights are less about ownership and more about recognition, it's still important to address them in employment agreements. So you can ask employees to waive their moral rights where it's legally possible to ensure that you have the flexibility in how this IP is used. And why being proactive helps. So including IP terms in employment agreements is a smart and simple way to just avoid potential issues and disputes. It gives everyone clarity around who owns what and ensures your business is in a strong position to leverage its IP. So by making these steps as part of your onboarding process, you can essentially protect your innovations and focus on growing your business. So moving on to the topic of restraints of trade and how it can protect your startup. So when an employee leaves the business, they're free to pursue new opportunities, which includes working for a competitor or approaching clients or staff. So for startups, this can be a real concern, especially if the departing employee had access to sensitive information or key clients and relationships. A restraint of trade clause in the employment agreement can help protect your business by essentially setting boundaries on what a former employee can do for a specific time and within a certain geographical area. So what can a restraint of trade clause cover? Restraints are typically tailored to suit the needs of your business. So for startups, it's quite common to include the following restrictions in areas like non-competition. So this would prevent a former employee from working for a competitor or starting up a competing business for a set period of time. It can include non-solicitation of clients. So this would stop the former employee from approaching existing clients to take their business to wherever they're working or just elsewhere in general. Non-solicitation of staff. So this would prohibit the former employee from encouraging team members or contractors to leave your current business and work with them. And lastly, we've got non-dealing. So a non-dealing restraint essentially goes a bit further than all of them and prohibits a former employee from providing products or services to a former customer or client, even if there's been no active solicitation involved. So some key considerations for enforceability. Restraints of trade are generally viewed quite skeptically by the New Zealand courts because they can limit a person's ability to work and earn money. So, for a restraint of trade to be enforceable, the employer must show two things. And the first one is a legitimate business interest, which is at stake. So, you could have examples such as protecting confidential information, trade secrets, key relationships with clients, suppliers, or staff. And the second one is the restraint has to be reasonable. So the court will essentially assess whether the duration, geographical scope, and the restricted activities are considered fair and necessary to protect your business. If the restraint is too broad or excessive, essentially it can be deemed unenforceable. It's important to also tailor restraints to the particular individual employee. So a one-size-fits-all restraint clause rarely works. And it's crucial to consider the employee's role, the responsibilities they have, and how much access they might have to any sensitive information. So, tailoring the restraint to the person, especially if they move into a more senior role during their employment, is also quite important. And also periodically reviewing and updating restraints to ensure that they remain relevant and fair. So, moving on to how to protect your business. So, to make the most of these restraint clauses, you need to ensure that they are drafted with care. So, ensure that the clause is actually specific and focused on protecting legitimate business interests. And secondly, communicating obligations. So, reminding any departing employees of their post-employment responsibilities, including any restraints that they've agreed to in their agreement. And lastly, seeking legal advice. So getting professional help to draft, review, or update your restraint clauses so they remain enforceable and actually are aligned with the current law. And why it's important for startups. So for startups where confidential information, trade secrets, client relationships are critical, a well-drafted restraint of trade clause can essentially be the difference between safeguarding your competitive edge or losing it to a former employee. So just before we do finish up on the content of today's webinar, I will go through some of the key changes to employment law that have been proposed. So the first one is in regard to unjustified dismissals. So the Relations Minister has aimed to introduce an Employment Relations Amendment Bill, which could go through as early as sometime this year. So essentially, this proposal is to set an income threshold for unjustified dismissal claims. So this one has been quite a controversial proposal, but essentially it's actually already in place in many countries, including Australia. Essentially, this means that any employee earning over $180,000 will not be eligible to raise a personal grievance for unjustified dismissals. The second is also related to personal grievances. So there has been a proposal to reducing remedies for employees who have found to be at fault during an employment dispute. So specifically where serious misconduct is involved. The employers propose to have no rights to remedies or reinstatement or compensation for hurt and humiliation where they're found to be committing serious misconduct. The next one is ending pay secrecy. So currently, you can have a clause in your employment agreement that prevents employees from discussing or sharing pay conditions with other employees or third parties. It has been proposed that employees will not be able to include this clause in future, but again, it is just a proposal. And lastly, the contractor gateway test. So this is important for a lot of startups who engage with a lot of contractors. So essentially, there is a proposed gateway test that will distinguish between contractors and employees. As discussed earlier, it is quite a gray area, and sometimes there can be a bit of crossover between when someone is a contractor and becomes an employee or vice versa. But the proposed change will allow for more clarity between when someone is a contractor or employee, and then it will reduce future disputes over their classification further down the line. So these changes are currently only in the proposal stage. The only confirmed change is the increase in minimum wage, which is happening on the 1st of April. But otherwise, there are some practical tips that you may want to consider, which is reviewing your employment agreements and contractor agreements against these proposed changes, and to consider what your business's stance is regarding things like pay secrecy, serious misconduct situations, and how your business may respond if the proposed reforms do take place. So that does conclude the main part of our webinar. You may find our publication, the How to Hire and Inspire Guide, useful. So you can download it by scanning the QR code on screen. You may also be interested in our upcoming webinar, which is Navigating the New Industry Standard Commercial Lease Terms, What Tenants Need to Know. And this will be on the 4th of March at 12 p.m. So I'm going to answer your questions shortly. So while I give you a bit of time to submit them, I will just take a minute to tell you about our membership. So by becoming a LegalVision member, your business gets unlimited access to our full team of 100 plus specialist lawyers for all of your business as usual legal needs. It's like having your own in-house counsel for a fraction of the cost. Our team can assist you with things like unlimited document drafting and reviewing of business contracts, unlimited legal advice consultations, and also unlimited domestic trademark registrations and much more. So as a LegalVision member, you won't have to worry about the cost of lawyers ever again. So think about it as having your own in-house counsel. We'll take care of all the business as usual legal work so you can focus on running your business. And if you are in-house counsel, we also offer a dedicated service to manage your high volume business as usual legal tasks. So to learn more about how membership or desk extension can help you, feel free to request a free consultation when the survey appears at the end of the webinar. So now we'll just get started with answering some of the questions. So we've got a pre-submitted question here. So does an employer have any employment-like legal obligations when engaging an individual, such as a contractor, where both parties sign a contract explicitly stating that this is the nature of the relationship? So while employers, I guess, have fewer legal obligations to contractors. We normally refer to them as the principal. They do have some responsibilities, particularly regarding health and safety, so non-discrimination and fair contracting practices. So obviously they aren't entitled to things like annual leave and everything, but being a fair and reasonable, counterparty is still quite important. So this is quite key to ensure that the relationship is genuinely one of contracting and not employment. So what happens if my employee doesn't have a written employment agreement and only an oral agreement? That's a really good question. So an oral agreement still amounts to an employment relationship. However, it is just a legal requirement by law to have a written employment agreement. And there are obviously penalties for not having a written employment agreement that I discussed earlier. The employee can also raise a personal grievance for disadvantage claims for not having an employment agreement. So to rectify the situation, it's always best to provide one as soon as possible, even if the employee has started work with the conditions that the employee has currently been working under. So what happens if we hire someone as a casual employee, but they end up working more full-time hours? So again, as discussed earlier, casual employees work on an as and when required basis. So you may have some employees working, like a full-time period over the summer on a casual arrangement, and the hours may look more full-time for a short period of time, and that's generally fine. Um, it is essential to remember that you don't have to keep offering them work and they don't actually need to accept the work. So if they are actually more of a permanent employee at this point, you might want to change their status despite what the agreement says. So we'd recommend updating the employment agreement to reflect the correct arrangement. And last one is, what are our obligations around KiwiSaver? So I touched on this lightly earlier, but essentially you should be automatically enrolling new employees to the workforce, and they are new employees. So they wouldn't have signed up for KiwiSaver previously. So they are between the ages of 18, they have to be between the ages of 18 to 64 if they want to be eligible and if they're not already members. If they are already members, then you can essentially just get them to fill in the correct documentation and start their employee deductions from the first pay run. And again, as I stated earlier, it doesn't apply to temporary workers and only casual workers. So there are a few documents you do need to ensure to provide your employees. So that is the KS2 and the KS3. And then your employee will essentially select a deduction rate. So that's something like 3, 4, 5, 8, and 10 percent. So that's their employee deduction, and then you would just need to contribute at least 3%. If you want, you can contribute more if you want to, but generally that is just the rate that you need to contribute in addition to their salary or wages. Um, I can see one more question just popped in. Um, does the requirement for a job description apply to a contractor? No. So with a contracting arrangement, normally there is a section for, it's like a contract for services. So you just note down what the services are. So this could be something like administrative services or consulting services. And essentially that's all you need to include. That is just because contractors are considered an expert in their field and they don't need, specific KPIs and a job description to tell them what they need to do as their job. Yep. So that is the last question that we have. Um, if you do have any other questions um, that you haven't managed to get through to us, if you want to just submit your details in the survey at the end, um, and then if you want to learn more about how our membership can help your startup, again, just send through your details at the end in the survey. So while this is a free webinar, we really do value your feedback. So if you could complete that survey at the end for us, we'd really appreciate it. Thank you for joining us today.